morning and welcome to the City of Palm Coast City Council meeting, virtual hybrid special meeting today. Due to the current threat of COVID-19, the City Council will be meeting in person, but limiting the in-person attendance in any room as outlined by the Centers for Disease Control. The meeting will also be held via virtual meeting pursuant to the Governor's orders issued on March 20th, 2020. Local government bodies may utilize communications media technology. This order was extended by order number 2246. As mayor, pursuant to the authority granted to me by the city charter, I declared a public emergency on March 15, 2020 in response to COVID-19. Furthermore, pursuant to those powers in the governor's executive order extended by order 2246, I suspended all city requirements that require a physical quorum to be present and conduct this meeting, and authorize this meeting be conducted as a hybrid communications media technology under the city's state of emergency proclamation for virtual meetings executed on April 3rd, 2020. And conducted city council meetings executed on September 3rd, 2020. Notice that this meeting was going to be held as a hybrid meeting by communications media technology and with limited in-person attendance was posted on the city's website on October 30th, 2020. Access to this meeting is being provided via live stream on the city's website at www.palmcoastgov.com and by calling in at 386-223-1690. Should you need any technical assistance, please call in at 386-986-2391. Today is November 2nd, 2020. It is 9 a.m. Please rise and join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Mayor Holland?
Here.
Vice Mayor Clufus?
Present.
Councilmember Branquino?
Here.
Councilmember Cuff?
Here.
Councilmember Netz?
Here.
Mayor, all members are present.
Thank you. We will move to agenda item number D1, which is a resolution. Consider the recommended order from the hearing officer relating to the city's motion to dismiss the appeal of the insurance bid protest. So I'm assuming, will you present first, or do we hear the testimony by both parties today?
It's my understanding that my role is to be your attorney at this meeting. So as you hear the parties that are going to be arguing this morning, and as you either wish to ask them questions or you wish to ask me questions with regard to how you may deliberate or what your options are, I've read all of the materials and tried to get up to speed on everything, so I'm basically here advising.
Okay, great. Thank you.
Sure.
So what would be customary then? Who would go first and present? Virginia?
I would suggest that the attorney let council know what the motion was made by staff's attorney, and just give a little brief history as to the process that took place with that motion to dismiss.
Sure, I'd be happy to. Basically, based on your motion, you sent the question on the bid protest to a hearing officer. The hearing officer then had a pre-hearing conference call with all the parties that were involved, and parties representing both of the insurers and also the staff's position or the city's position. And I was also on that call. And so basically, again, I was in more of an observer capacity, just trying to understand, because this gets kind of complicated when you come in at the last minute trying to figure out what's happening here, just as I'm sure at certain times it's been very complicated for all of you too. This is not simple, and I don't think we should treat it as simple. It is complicated. So everybody basically, there was the question with regards to the city's position was that the bid protest should be basically dismissed because the appropriate bond was bid bond in the appeal was not provided according to city code. The other side that's representing that insurer basically made arguments with regards to why they felt that what they did with regards to the bond was sufficient. There are other issues that are involved here or statements that have been made with regard to the process. So basically, after about a 2.5-hour phone conversation with a lot of different lawyers talking, the hearing officer has made a recommended order. And basically, his recommended order at this point is that you all would dismiss the bid protest, the protest with regard to the bond, and let him proceed forward in his role as the hearing officer to basically come back to you with a decision as to the substance of who, in an attempt to resolve this dispute. So this is kind of, it is the question of whether appropriate insurance was provided as required by your code is the specific issue that is in front of you. But how you decide, and you may want to discuss this later, has different alternatives to you, whether you get to a point where you would say, okay, we're going to take the hearing examiner's recommended order and say the bid insurance we're going to push that to the side, and we're going to deal with the substance of this protest, statements that are being made, etc. And then as a hearing examiner, I'm going to bring back to you an order that is substantive. Or you could basically not accept the hearing officer, examiner, I call him either one, his suggested order and take the city's position or city staff's position that Mr. Shepard is basically arguing, saying this bid protest should be done and over with because the code was not followed correctly with regards to that issue. And so we're done. You all awarded it. And this matter then can proceed to court for further litigation if warranted. So that's kind of, it is, and I'm not trying to say this is not complicated, and the lawyers have very lengthy, specific arguments with regard to their positions. But in the end, that's what you all are going to be asked to decide. Are you going to accept the hearing officer's suggested order, and he continues to be your hearing officer and then goes into a full-blown hearing on the merits? Or are you going to say the city position, I agree with that position, let's just get out of this bid protest, we awarded it, we're going to move forward with our insurance award, and then let the parties proceed with this matter further in court if they wish. So that's kind of, does that give a good explanation
Yes,
for all of you?
There's a third option available as well, which is in the agenda packet. Throw out all bids and rebid it, strengthen the bid, and prior to the release of the bid. So you have three options that are in your agenda packet before you that are available to you today.
Yes, and if I could just, I saw that was in there, and I know there is issues with regards to coverage and when policies are going to expire. And I have no knowledge with regards to any of that, and the clerk knows far more than I do about it. I don't know or I don't know anybody, and it certainly can't be me, that addresses that third option of what risk are you in if you do that. Because again, my limited understanding was your coverage is due to expire. So, so I think there, if that is a serious option you wish to consider, we may need someone else to be able to address that. And I have not met your city manager, but perhaps he could address it, or the clerk could address it.
Our city manager's right there. That's okay.
Nice to meet you.
Appropriate to answer now, or should I wait?
Excuse me?
Is it appropriate to answer now, or should I wait?
No, go right ahead. I just didn't want, as I'm trying to kind of...
My understanding is we have month-to-month coverage through the league until this matter is resolved. So we don't have an end date, isn't they said resolve on or before. I'm sure they're within their rights. Again, is just to make everyone aware of a possibility. Do we have a written extension until the matter is resolved, Virginia?
We have an email stating that we can go month to month.
So it should be fine until the matter is resolved.
I think at this time it's appropriate to turn it over to Mr. Schumer, who filed the motion to dismiss.
Yes, can you hear me?
And each party will have 10 minutes. The timer is set in accordance with the resolution that council passed in October, referring the matter to a hearing officer on recommended orders.
Yes, can the council hear me?
Yes.
Good morning. My name is Jacob Schumer. I'm an attorney with Cliff Shepard's office. And yes, we filed the motion to dismiss on behalf of the city staff. And I agree with Ms. Siegel-George in that it is both complicated and simple. But luckily before you today is the simple question, which is that even PREA will admit that what they did with the bid protest bond today, or in September, did not comply with your code. And so the question that comes before you is what to do about that. Ms. Siegel-George did go over the background a little bit. I'm going to go step by step on the timeline. On September 1st, the council decided to award the RFP to the League of Cities, to FMIT. And within a few days, PREA appealed to the financial services director, Ms. Alves, who I believe is on the call. And after that, Ms. Alves denied their appeal. When she denied their appeal, she specifically told PREA that they need to submit a bid protest bond in the form of a cashier's check, certified check, or money order. And that is something that's specific in the code. And when PREA made their appeal, they specifically cited Section 229 of the code, which governs all these bid protest procedures. So they are working entirely under your code. When all this process started, that's under this code. And so they need to submit that cashier's check in order to appeal to the city manager. Instead of what they did was they submitted a surety bond backed by an insurance company under the form that's required for Florida state agencies. So not the city code version, but the state of Florida version. And those two bonds are very different in some significant ways. First, it requires the city to go to an insurer to get any money back from the cost of this appeal. And that's what the bid protest bond is for. It's to protect the city financially from the cost of appeal, including attorney's fees, including costs of getting month-to-month coverage, that kind of thing. And it's a common form of bond whenever you have an appeal that delays somebody's award. And in this case, the costs are going to be high, are already high. I imagine we've undertaken, I believe it's over $20,000 in fees just as of the end of last week, and that doesn't include the cost of the hearing officer. Second, it changes the bond, includes a lot of statutory references that don't make sense. So it's not clear that the city would ever get its money back under that bond, because it's for state agencies, not for local governments. It also it doesn't allow the city to get any money back until the end of appellate court proceedings that don't exist in the local government code. And so that would also delay the recovery for potentially years. or just result in no recovery at all. So this is, so it's not just a technicality. This is a significant difference between the two bonds. And it's just like a, an application fee. You don't get to get all the application work done without filing the application fee because you don't like the application fee. And that's kind of what PREA did, which is after the city manager denied their appeal, first reason given being that the bond was not valid, was not compliant with the code. Instead of correcting it, they filed the appeal with the council, rejecting the bond requirement, basically saying that the bond requirement is illegal. And so their argument was it was internally inconsistent and something about due process. I couldn't find any authority saying that it was illegal, and so they just rejected the bond requirement and moved forward from there. And so now we're in a position where, and then at that point, the council referred all of this to the hearing officer. And so we made the motion saying you should get rid of this appeal because they still haven't complied with the procedural requirements, and that is the bid protest bond. And the city manager made his recommended order, or the hearing officer. The hearing officer did agree that PREA did not comply with the city code, but his recommended order was to allow the appeal to go on for a couple reasons which we disagree with. The first being that, or one reason we disagree with, the other one being within you would have more expertise on than we would. First being that the city code doesn't apply to this appeal. We disagree with that because the city code states that it applies to any bid. It applies to both protests of intended results and actual results. So that is staff declarations of intent to award and the city council's decision. And his interpretation was it only applies to staff decisions, which we don't agree with. And if it did, and if that was the case, then that would be a different reason to dismiss this, because what are we doing if we're not working under that portion of the code? Second, he was under the belief that the council referred the matter to him so that he could take a look at the substance of the argument between weighing the two different contents of the bids. And we didn't read it that way. Y'all would know more about that than we would. But basically our interpretation was that you gave the hearing officer to have fresh eyes, a third party look at it, the entire thing, including the city manager's decision that the bond was invalid. And so we moved to dismiss because there's a procedural requirement that is not met and it places the city in financial risk. I expect Mr. Bayard to argue that the city needs to give PREA a chance to cure their mistake, to correct the bond issue before the city council decides to dismiss it. And Mr. Bayard is correct that they need to be provided an opportunity to correct their bond mistake before the city dismisses it. The thing is, they were provided that opportunity, which is when the city manager told them your bond was insufficient, and then 3 days later, they filed an appeal rejecting that opportunity and saying that the bond requirement is illegal and we're not going to comply with it. And at that point, they could have complied under protest if they had an argument about the legality of the bond requirement. They could have submitted the bond requirement saying, we think there are problems with this code, but we're going to comply and we'll fight about what to do with the bond later. And by the way, they get the bond back no matter what if they win under the code. And so that the city council, in our view, doesn't need to worry about giving them an opportunity to cure unless you would like to do that. So basically, the city council has 3 options. You can dismiss it as we suggested, and we can prepare a proposed order to that effect because they haven't complied with the bid requirement. Agree with the recommended order saying that for whatever basis you would like, letting the case to continue, possibly with an opportunity to hear, or just go through rebidding the process. And at this point, I'd be happy to take questions or let Mr. Bayer take over.
Council, any questions or comments at this time?
Not at this time, but we could ask questions a little later if we want to. Okay.
Always have
Not
the-
at this time.
Well, actually, I do have a question. My understanding is, and it's somewhat limited here, the issue of the surety bond versus check, this, that, and the other thing, Mr. Bayer is arguing that the decision was not a decision of staff, it was a city council decision, and city council is not included in or referenced in the ordinance. Could you comment on that?
Yes, and the city staff is not isn't listed in the reference in the ordinance either. And I'll just pull up the section of the code which is discussed. So first, it's section 229A of the code, which sets out what bidding procedures are subject to the appeal process. It says, in case where a bidder or interested bidder wishes to protest either the results of or intended disposition of any bid, the following act is required. So it's any bid, and it's the fact that it says results of or intended disposition means that it expects that there will be times when the council reverses the staff decision. And another reason thing to think about is that they actually submitted, when they appealed to the city manager, this bond requirement is in the same paragraph, that's section 229B1, that authorized them to appeal to the city manager in the first place. So they appealed to the city manager under that portion of the code, and if they are arguing that they don't have to comply with the big bond requirement of that portion of the code, this shouldn't have been, nothing about this should be entertained, because they're basically getting the benefit of one half of a paragraph and rejecting the cost of the other half of the paragraph. I'm not sure if Mr. Bayer is going to be arguing that, because if the ordinance doesn't apply to this, then he doesn't have a right to appeal at all. The PREA doesn't have a right to appeal at all.
Thank you.
Any other questions before we move forward?
May I ask one? Just for clarity, just to make sure I understand, PREA was also made aware that the surety bond wasn't sufficient or not in compliance with our code, and I believe I heard you say that they still decided to move forward with the bond issuance instead of the alternative, the cashier's check?
Yes, on the letter, the city manager's letter on September 21, the first stated reason for rejection of the appeal was the bad bond. But the city manager allowed them to continue their appeal, giving them a few days to file an appeal to the city council. And instead, when PREA filed that appeal 3 days later, after being given notice of the defective bond, PREA argued that the bond requirement was invalid as internally inconsistent, and basically said, here's our surety bond, we consider this to be sufficient. And so they basically argued, yes, we didn't comply with the code, but we consider the code to be invalid, and so this is our method of compliance.
Yep. One more question to follow up. Is there any precedent that would make you say that the verbiage in our code is invalid? Is there anything? Obviously, my experience here doesn't span, horizons. So, are there issues with the verbiage in our code where this isn't a normal situation?
I would say no. I'm not aware of anything that would say that it's invalid. I think PREA argued that it calls for automatic forfeiture of the bond. That is, the code calls for automatic forfeiture of the bond. It doesn't say anything about that. It does say that the bond is forfeited if they lose their appeal, which is common with appeal bonds. That's what the purpose of the appeal is for, is to protect the initial winner, in this case, the League of Cities and the city, from the cost associated with dealing with an appeal that doesn't have merit. And so I'm not aware of anything that would say that this was somehow invalid. It gives the city discretion in how to deal with that forfeiture. So theoretically, the city could return any costs or any part of the bond where the city didn't incur legal fees or anything that would cause it to go over the bid amount. So the bid amount is calculated based on the contract amount, or the bond amount is calculated based on the contract amount. Theoretically, the city could return some of that money if the costs are low, but here you didn't even have the opportunity. So I don't know any reason why. I'm not aware of any authority that would suggest that the requirement in the code is illegal.
Understood. Thank you. That answers my question.
Any other questions, council?
Not yet.
Okay, so we'll hear first from
Bayer.
Mr. Bayer.
Good morning, members of the council, Madam Mayor. Take my mask off, is that okay?
Yeah.
Either top. I'd like to clarify a couple of points. First, I'd like to reserve 2 minutes in case FMIT's counsel, I believe is on the call this morning, has any comments so I can rebut anything that they might say. But first, opposing counsel mentioned he started his history September 1st. Let's back up a couple months. June 30th, the notice of intent to award the bid was issued to my client. In other words, we were the prevailing party back on June 30th of 2020. What happened next, if you've seen our amended motion on this case, is basically there were a number of ex parte communications between FMIT and city staff. So instead of FMIT at that point not being the prevailing bidder, they then went, and we've got the emails, and said, you guys need to change your mind. And they went to the city attorney, Mr. Garganisi, you need to get the commission to change their mind. We then found out in a public records request since the last time we were here that your city attorney has billed FMIT $1.3 million over the last 3 years. A clear conflict of interest is what we allege in both our original petition as well as our second petition. We also asked you last time that we were here to get a hearing officer that understands the bid process. Well, you did that. You got Darren Elkine, city attorney for DeLand, a lot of years in the job, a lot of experience in this area. And he looked at your code, he heard the arguments, and what I think you need to look at is in section 2.29, it states that the appeal, this notice must be received by the Administrative Services and Economic Development Director no later than 3 business days after the city's notice of intent to award. In other words, June 30th is the triggering date. My clients then come to the city commission meeting or attempt to log into the city commission meeting on September 1st. Didn't get a chance to oppose this because of the telecommunications issues they had at that time. But then basically are under the gun. They got to do something to preserve their rights. So without an attorney involved, they filed the initial appeal. We were then told what the process was to go forward, although we're saying it's not our process, and that's what the hearing officer agreed to. He said there is no bond that's required because it's not an appeal of the notice of the intent to award that was done back on June 30th. It's an appeal of your decision as a city commission. So you've got a hearing officer that understands what he's doing, and that's his recommended order. We've also provided case law in our motion that if you do get to the substance or the form of the bond, an appellate court, so in other words, a case that went through the bid process, went through trial court, went up to appeals in the 3rd District Court of Appeals, said that there's not a substantial difference between a cash bond and a surety bond. One of our concerns with the way your code is written, and this is where our due process argument comes in, is that your code says that it's forfeited if staff determines that it's without merit. Well, both of the denials that we had, there was a summary conclusion. City attorney doesn't have a conflict of interest. He's doing what we told him to do. It's without merit. Automatically, $54,000 goes out the window because there's no standards to determine whether an appeal is with merit or without merit. We don't get a hearing. We don't get an opportunity to say, well, wait a minute. Didn't you see this email from July 24th where counsel for the League of Cities is contacting your city attorney and trying to get him to change the position? In other words, in direct violation of your anti-lobbying provisions in your bidding code, there's these communications going back and forth, but city staff said, nope, your appeal's without merit, without any recitation to the facts that underlie their decision. So our position is, hearing officer's correct. Let's have a hearing on the merits. These are very serious allegations, and we understand we have a burden of proof in establishing those. This needs to go to a hearing. If not, we'll go to court, but I think you as the city commission, that are elected officials that are responsible for your staff, should be the ones to make these findings. And I'd be happy to answer any of your questions.
Council, any questions?
Yeah, Mr. Baer, if you have such difficulty with the unfairness of the city ordinance that you are proceeding under in this appeal, why aren't you in circuit court already?
That could be our next step. I mean,
Well, I'm not trying to be argumentative, but that's a bit. And my other procedural question is, during the argument on the motion to dismiss, does your client take the position that the city is now stopped from enforcing or has waived the enforcement of 2-29 as far as the bond requirement is concerned? Is that going to be a legal issue we're going to have to go to court to litigate after this appeal is over?
Right, because the way your code is written, that it talks about an appeal of a notice of intent to award.
Okay, but I'm not talking about the procedure and the timing. I don't think anybody is trying to say, at least I don't read it that way, that your client doesn't have the right to proceed under 2-29. My concern is you want to take the good. You don't want to spend the money and the time to go to circuit court, even though you have all of these substantive issues about due process and fairness and so forth. But you want to get the benefit of not having to post a essentially cash bond as opposed to a 120 bond. I mean, I read the hearing officer's proposed order with respect to the hearing officer, because I know he's qualified and knows what he's talking about, as trying to divide the baby. I mean, we all want to get to the merits on this issue, get this decided, put it behind us, and get the city adequate insurance coverage. But it seems to me you're trying to have it both ways. If you really have this much problem with the process we're going through now, you should be over in Bunnell in circuit court. If you don't, the last thing I want to do is see the city have to face future bid protests where somebody brings in, their new car and says, this is an adequate surety bond for this protest. You can't enforce 229, so we have to be able to proceed. I mean, I want to get this issue settled and I want to get it behind us, but I need to know whether your client takes the position that if we enforce the bond requirement as it's written, that we're going to wind up in circuit court, in which case, if we are, my question is, why aren't we there already on the merits as well as on the bond issue?
Well, again, the way the process starts is the client files the appeal within the 3 days to protect their rights, and they're directed by staff, okay, this is the way you got to go, and we're saying, wait a minute, we don't agree with the process, but we preserve our rights, that's the way we went initially.
Okay.
To answer your question, if you look at St. Johns County, they have a much more detailed process in their regulations to say, okay, this appeals with merit or this appeals without merit. There's some standards there to guide the litigants, to guide the protesters as well as your staff on how the process can be run. Your ordinance doesn't have it.
I understand that, but I hope you understand the purpose of my question. If your client filed the appeal within 3 days of the council's action to reverse his decision, fine, I get that. Why did your client think that a surety bond under Chapter 120 met the requirements of 2-29?
Because the security is there. I mean,
No,
the $54,000 is there, so there's a process under the bid bond that if you prevail, that you
with respect, counsel, the money's there, but in my experience, well, we don't need to go there. I'm not sitting here as an advocate for the city. I'm sitting here trying to get to the bottom of this. Is your client not willing to comply with the provisions of 2-29 in order to proceed with this appeal under 2-29?
I'd have to ask them, but I mean, it's
our
position. It's adequate what we have in place right now.
But is it your position that it complies with the requirements of our current ordinance, whatever the merits or the defects of that ordinance? I'm not arguing that we shouldn't revisit this as a legislative body and revise those provisions. Maybe St. Johns County has a better plan. But clearly, and the hearing officer said as much in his footnotes, what your client did does not comply with the provisions of 2-29.
Well, and that's where we have the case law out of Miami that states that it's not a material difference. And in that case, they reversed it when it was a difference between a cash bond and a surety bond, and said that the party that posted the wrong bond prevailed, and they got awarded the bid.
Okay. What was the language of the ordinance they were appealing? Do you have that?
It doesn't cite it in the case, but basically the court stated that the appellant had submitted a cashier's check instead of the bid bond, was not a material variance, thus the trial court improperly ordered the county board to reissue an invitation for bids.
I have some more details on that case, if the city council would like to hear them.
Wait for a minute. Let's get through this.
No,
question.
I wasn't trying to preempt this. I mean, this is an issue for me, and my concern is, number one, the merits of this appeal and getting it decided fairly and fully on the merits. But I am greatly concerned about the hearing officer's apparent legal conclusion that we have somehow waived our right to enforce the provisions of 2-29 in this case, which means we'll be faced with that same complaint next year, the year after that. And when I say we, I mean whoever is on the city council and whoever the city staff. That's, to me, this is a relatively straightforward procedural issue. And the way it is solved is if the appellant is proceeding under 2-29, they post the bond required by 2-29, notwithstanding whatever the rationale of the 11th Circuit case that counsel is citing, or the 3rd District, I guess, would be. And then we proceed on the merits. And, I mean, that's what I'm trying to get to. I am unimpressed by the proposed order of the hearing officer, despite my great respect for his ability. And I think I see what he's trying to do. But I'm concerned about the future precedent that this is going to create, and the claims of estoppel and the claims of waiver. And it seems that the appellant could fix those claims and those problems very easily, unless I'm missing some legal principle here.
I don't know if you want my response.
No, again, Dennis, please, I'm not trying to be argumentative. I want to see this decided on the merits. But it seems to me that we're spinning our wheels and we're wasting a lot of time on procedural matters that could be easily cured. And, yeah, I would like to hear the appellant's response. I'm not trying to be unfair to the appellant. I just want to get to the bottom of this so we can move on.
Again, our position is we agree with the hearing officer's recommended order as to the nature of this appeal, that it's because it's from the city council's resolution, not a notice of intent to award the bid, that it removes that requirement. We raised that at the case management conference 2 weeks ago, and we had that discussion.
Okay. But you do feel that you are still proceeding under 2-29, even though your legal position is that the city council resolution that created this issue is not a notice of intent to award. It was a resolution reversing a prior decision on a notice of intent to award. The 229 applies to this situation, but the portion of 229 that specifies what the bond is in an appeal under 229 does not apply to this situation.
That's correct.
Okay, thank you.
Any other questions?
Council, any other questions for Mr. Bayer at this time?
I heard, may I?
Yes.
You said a 120 bond. Does that mean that you only have to stake 5% of what you would have to with the cashier's check? Is that?
I'm sorry, I didn't hear it.
I heard the term 120 bond as the surety bond. What does that mean, 120 bond?
Well,
120.
The state of Florida has its state bidding procurement process with their appeal process and the bonds that are required. So, for example, if I was bidding to repave State Road 100, I'm a state bidder. There are bonds, and I'm unsuccessful. There is a state process that's required. So the form that we use is taken directly out of Florida statutes. So it is used statewide, and there's a difference between municipalities. As your council has pointed out, you all do have some flexibility as far as what you adopt for your local requirements. There still has to be a component of due process. For example, this whole issue about whether it's with merit or without merit as far as our appeal, we should have an opportunity to challenge those, which is not in your ordinance.
Okay,
It
so
is in the state.
the 120 bond doesn't signify that you only have to stake 5% of what would be the full amount of the cashier's check. That's not.
The amount is the same amount that would be either way. It's
Okay.
it's 54,000 and change, whatever that number is the same whether we did a cashier's check or a surety bond.
I would ask Councilmember Cup, would you explain a little bit of your line of questioning for me to understand procedurally what you're trying to get to? Meaning there are several options or a few options in front of us to proceed with the concern of the bond issue being one that obviously they're attaching to their argument. Are you stating if that was off the table, you'd have a different scenario painted?
Again, and I'm trying not to be the city's lawyer here, but my concern with the posture we're in here today, and that's what I was trying to, and again, my apologies, Dennis, we've known each other for decades, and I'm not trying to be argumentative. My concern isn't the current situation. My concern is we have an ordinance which has not been declared to be invalid or unconstitutional or unconscionable or fattening that says you do things a certain way. The appellant has filed their appeal under that ordinance, and we have agreed to have that appeal heard and to go forward. We've appointed a hearing officer to listen to the merits of the case, and my concern is that if we let the appellant in this case decide whether a Chapter 120 surety bond is the same thing as the bond that's called for under our ordinance, that the next time we have a bid appeal on, it wouldn't be the paving of State Road 100, I hope, because that's a state road, but let's say it's the paving of Old Kings Road or Matanzas Woods Parkway, and we have a multi-million-dollar contract that's hanging fire. We're going to have to relitigate this issue because the bidder the bidder who's protesting the award shows up with a 120 bond or I don't mean to be sarcastic, but he parks his new Corvette out in the parking lot and gives the city clerk the keys and says, here, you hold this until the appeal's over. That's worth as much as the cash bond that 229 requires. And we will be legally estopped from not agreeing with that because we let this appellant make up their rules for what meets 229. How do we stop future appellants from doing that? And that doesn't mean maybe we don't revisit 2-29 in the future as a legislative body. But for now, it seems to me that we need to let this appeal go forward and we need to let it be decided on the merits. But I think we are setting a dangerous precedent if we let it go forward on the merits, on the part of the appeal that the appellant wants a ruling on and that we want a ruling on, but we just sort of shove the procedural issues to the side. And even if this appellant agrees that, that's off the table, we're waiving it, we're not going to, whatever. It's not a question of what this appellant would do in the future even. But between the parties that we have here, I think we could have an agreement that this wouldn't be thrown back in the city's face with a claim of estoppel. But it has no, as far as I know, unless the attorneys can tell me differently, it has no binding significance on the paving contractor for the widening of Matanzas Woods Parkway 5 years from now who comes in and says, well, you let PREA make up their own bond. Why should we have to comply with your ordinance in order to move forward with the appeal? That's really the nub of my appeal. And if somebody, the hearing officer's proposed order tries to finesse that, but it does it in a way that I'm not comfortable with. It basically says, as I read it, he doesn't think 2-29 is the proper avenue of appeal here. But since everybody kind of agrees that it is, everybody can kind of agree that if we want to accept a different bond than the one 2-29 clearly requires, it's up to us. And from a practical standpoint, I'd love to just say, sure, let's do it. but I think the council needs to consider precedent, history, and what we're going to be faced with, we, the city, a year from now, 5 years from now, 10 years from now. And if the city is willing, I don't even want to go there, because that's, again, it's like getting into the merits of the appeal. I mean, I don't disagree with the appellant. There's plenty of smoke here, at least based on their arguments. I'd like to see if there's any fire, and I'd like to get this decided on the merits. But I'm very uncomfortable with letting the parties make up their own rules when doing that, in this case, could tie the hands of a future city council in a similar situation, but maybe in one where the city has more at stake. They have a project that they need to get done for public safety reasons, but that project is on ice for 6 months or a year while the protesting bidder fights over it. I think we need this issue cleared up, and I think we need to move forward with this appeal, but I don't know how you do that without jeopardizing the process in the future. And that's my concern, as clearly as I can state it.
Go ahead, Councilman.
Let's start at the very beginning. The whole purpose of a bid is to get a package of quality services at the best price for the city. That's why you bid things. I look at the three options that are put on our agenda page. Option one, accept the hearing officer, and you could continue on with the dispute. Option two, you reject it, and you're going to continue on. Either option one or two is going to involve the city in protracted, expensive litigation. I happen to like option number three. Throw the bids out, rebid it, and in that opportunity, if our attorneys feel there is some inadequacies or inconsistencies, we can amend the ordinance for the bid process. As long as we have an agreement with our current insurer that they will give us month-to-month coverage, I think throw the thing out and start over from scratch. Because the process that we're talking about, somebody's going to win and somebody's going to lose, but all the attorneys are going to make money. So, well, I happen to like option three.
Say that like it's a bad thing, John. No, for the record, I was being facetious, but it's a friend of mine's favorite attorney joke. Please excuse me.
So since Councilmember Netz has brought up his choice or his preferred option, any other council member wish to talk about their approach and what they'd like to see?
And if I could, I'd like to hear from both attorneys about their views on option three.
My question is, aren't we opening a can of worms by not taking care of this? Because either we're going to, right after this, going to revisit our ordinance regarding bids, or we're going to fall into the same problem. Go back to what Councilman Babcock said. Basically, are we going to create case law? I don't know. I just think that has to be clear as to what next year it's going to happen on Old Kings Road. Is anybody going to do the same thing? And then we stop doing this. This is a simply complicated process, for what I understand. Okay, and the more I hear, the more confused I get. Okay, so I would like to be clear that this is not going to turn around and come and bite us in the rear end. That's why I would like to go a little further down on this before we just move and dismiss everything. Because what stops them, an appellant, to do the same thing again? That is my confusion. Okay, and if we make a decision one way or the other, maybe we don't have that problem. One way, it's already cost us more than $20,000. The appellant hasn't put up a penny other than a surety bond. So for them, it's my cake and I'll eat it too. So that's why we have to make a decision. Thank you.
So, Mr. Bear, I'll first give you the option with the question posed by Councilmember Netz as far as your thoughts on the rebidding, and then I'll ask the other attorney to also answer.
We really think the merits need to be determined one way or the other. I mean, these are pretty serious allegations. If it's rebid, there need to be safeguards put in place to prevent lobbying that occurred the way it did this time. There need to be conflict of interest protocols put in place. But again, just read through the emails. The process, the case law when it comes to bid protests talks about having a level playing field that's free from any influence of fraud or improper communications. So if it's going to be rebid, it needs to be under different criteria just to make sure that everybody gets an equal opportunity. But we really think that the allegations, I mean, most of y'all know me for a long time. This is pretty serious stuff. We wouldn't have brought it this way. We posted the bond, and we can get back. Don't need to get back to those merits, but we did what's required in the state of Florida. We think if you go back to rebid, it's got to be under completely different circumstances than the way this last bid was processed by staff, and the lobbying that was allowed to occur by our competition.
Sir, with all due respect, do you suspect any fraud on part of the staff? Just for the record.
What I suspect is that you have very specific criteria when you submit a bid to not lobby staff. What happened here is, and I can read you one of the communications that occurred a month after the bid was done and the unsuccessful bidder didn't have to go through the bid process to appeal like we do, where basically it's to one of your staff members and says, and this is from John Lagon, who works for Florida Cities, says, I hope you're staying well and being safe. I looked over the PGIT or the PREA proposal and was disappointed to learn that the city made the recommendation to change insurance carriers. Then he goes down point by point with some of the issues that your city attorney then used in his report to disqualify my client. So in other words, it was our competitor that was telling your staff what was wrong with our bid, completely outside in violation of your anti-lobbying rules while this was still under consideration. And then there's communications before that from the Florida League of Cities to your city attorney saying if my client's a successful bidder, he can't represent the city. So it's Mr. Garganese can only work for Florida League of Cities, but couldn't represent my client if you had awarded the bid to my client. So it's highly inappropriate. We think there's a conflict of interest there, and we think it violates the rules. And that's what we'd like to see not happen again.
Okay. I'll ask the other attorney for comments, please.
I'm not sure if counsel for the League of Cities is on the line. I haven't heard from him yet, but they might have an opinion as to that counsel might want to hear. It sounds like PREA wants to go to a final hearing on whether or not there's merit to their appeal. Putting aside anything to do with the city attorney, we don't believe that there is merit to the appeal under the established criteria for when a city council decision to award a bid can be overturned, because all of their allegations have to do with the city attorney, not the city council that actually made the decision. City attorney's opinion, and not to get too far into the merits already, but just responding to what Mr. Bayer said, the city attorney provided an opinion regarding documents that were in front of the council and fully able to be read. So I'm not aware of any situation in which the council's decision to take information or opinion from a witness is somehow compromised because of the decision to take that testimony. Otherwise, every time an applicant comes in and provides an opinion and council accepts that opinion, it's somehow invalid, even though the applicant wants their permit, whatever kind of permit it is. As to the anti-lobbying provisions that he talks about, all those emails came after the staff notice of intent to award, and so basically, Mr. Bayer is arguing that they weren't allowed to contact anybody on city staff after the staff had made their decision, which may be an argument, but PREA was also trying to contact the council before the council made their decision. So they were both trying to do that. I don't think that that's something, and the RFP just says that if you violate the anti-lobbying rule, it may be disqualified. And the council can decide if that's important to you. But there's nothing that legally requires that, in our view, that legally calls into question the fundamentals of the city council.
Well, let me state for the record, I was not contacted or lobbied by either entity throughout this whole process. So I'm not sure where you're getting your information that council was lobbied by the appeal.
Sorry, I was talking about when they tried to call into the meeting on September 1st, before the dispute was actually voted on, to be clear.
Oh.
I'm not saying that there were any emails or anything like that. If we don't have any indication of that. I'm talking about when Priya is saying they violated the anti-lobbying provision by contacting staff after the notice of intent to award. The same provision prohibits contact with the city council before the award is made. And they were trying to do that when they called into the meeting, and in fact complained that they couldn't do that in their initial appeal. So there is some, if you believe that provision of the RFP, which prohibits lobbying, also prohibited contact after the notice of intent to award, then they were trying to violate the same provision. And there's no indication that the city was somehow required to disqualify anybody based on any kind of violation of that provision.
Okay. Go ahead, Mr. Bear.
Well, I just want to clarify, my clients did not lobby staff at all after the notice of intent was issued on June 30th, so there was no improper communications whatsoever. Yes, they did try to participate at the September 1st hearing, but as we've alleged, for whatever reason, they were not able to communicate with the city council. I just want to clarify that. We do not have any communications with staff.
Thank you. Okay, council, want to hear from each of you again what your thoughts are. And Councilmember Netz, I'll go back to you regarding Mr. Bayer's comments. If it were to go back out again, what would you recommend as a process that would put some of these provisions in place?
Madam Mayor, I had a long drive up here and got lost, but could I have a 5-minute break? I didn't want to just run out in case any of you had any questions. So,
oh, okay. Yeah.
if I could,
You'd like a break?
I just need to use the restroom.
Oh, okay.
Sorry. Right through here. Thank you.
Take a break?
Shall we take a 5-minute break?
Yeah.
I think we probably need to have the attorney here, so
Yes.
take a 5-minute break. Okay, I'm going to call this meeting back to order.
Gotta go. Yeah.
Are we on?
Yes.
Okay. So Councilmember Netz, I asked you a question prior to our taking a brief recess, and then I'll look to the attorney to answer some questions as well. If you were to propose to putting it out to bid again, how would you propose it based on the inquiry from Mr. Bayer that it would be a level playing field, and how would you approach that?
Well, I think it would be a level playing field, but the advantage that I see of option 3 is that it gives, if in fact there is any inconsistency in our ordinances, it gives us an opportunity to correct that or strengthen it or whatever is necessary before the bid process proceeds again. Option 1 or 2, somebody's going to be unhappy, and you're probably going to have to see this process extended. I think the best interests of the city are to get the best possible package of insurance at the best possible price. Just as rebidding would give the city an opportunity to clarify or strengthen or adjust, it would also give the two companies an opportunity to review and modify their bid. The end result, in my opinion, is the city of Palm Coast becomes the winner.
Want to respond?
Just for the record, we discussed with my clients, we do not have an objection to number 3, doing the rebid. We don't object to that. We think we don't want to engage in protracted litigation. We would just as soon go back to a rebid.
Okay, thank you. Council, what are your thoughts about the options before us?
Well, my concern with number 3, playing devil's advocate, would be that we set a precedent where someone could come before us and have an surety bond or other type of issuance that isn't compliant with our code, and then it results in the bid process being thrown out and going back to bid. It almost seems like that could be an unfair advantage for someone who's just protesting bids to try to get them put back out to bids. I feel if the merits are as substantial as we've been told, that number 2 would actually be probably the best way forward, and I would suspect that their client wouldn't have that much trepidation about putting up an actual cash bond or whatever the verbiage is instead of an surety bond. I think that we should get to the merits of the case. I don't think dismissing this based on the failure to have a cash bond is the right way to move forward, because it does seem like there could be potentially be merit here, but I think also the confidence of that merit directly relates to how likely they are to put up the cash bond. So my issue is with number 3 is that it sets a precedent the same way that we spoke about earlier, but I would prefer that they were to put up the cash bond so that they could move forward through our bid process, through our bid appeal process, the way that we have it laid out in our code.
Councilmember Branquinho or Cuff, would you like to comment on your choice? Councilmember Cuff?
I'm inclined to agree with the Vice Mayor. I mean, I see the appeal of option 3, and if the appellant has no objection to it and the other party has no objection to it, it's my concern with that is I'm not sure what was wrong with the original proposal, or how we would structure a new RFP that would get us a better product, although I agree with Mr. Netz that if that's the result, that's a good thing. To me, this is a fairly minor procedural issue that's being caused by the appellant. That if you want to appeal under 2-29, which they apparently do, 2-29 is clear. My comments about revisiting the ordinance in the future at this point are just rhetorical. I mean, I'm not sure, absent advice from our city attorney and from studying other cities' codes and other counties' codes, that there's anything wrong with 2-29. And the appellant's stated fear that they are going to have $54,000 confiscated or snatched up by the city of Palm Coast because of the way 2-29 reads, fine. If I were the appellant, I'd probably say the same thing, but even though it will not be me sitting here and ultimately listening to that argument, I would certainly hope the day would never come that a city council of this city would allow that result. If there are reasons to forfeit the bond, then the bond is forfeited. If the person who loses that surety, that security, feels they are aggrieved, they can appeal that decision to the court. So to me, that's a make-weight argument, that there's something wrong or unfair about our ordinance. There are many, 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 many dollars at stake to the city and to the bidders in this process. I mean, insurance is a huge industry. And to me, the relatively minor inconvenience of this appellant complying with the appellate process that they are proceeding under is greatly outweighed by future challenges to this process by other bidders who say, look, you let them do it, why not us? I mean, to me. So I think that rejecting the recommended order but giving the appellant sufficient time, not that they haven't been given sufficient time based on the letters from our finance director and from our city manager to comply with 2-29 is the proper decision for what's facing us here today, and would allow the case to proceed on the merits through the hearing officer and then back to the city council for a final decision. And if anybody tries to steal anybody's surety And I'm not on the council when that happens. I'll be standing at the podium telling whoever is on the council when that happens that they're doing the wrong thing. And I wouldn't expect to have to do that because I don't think that that's something that is likely to happen. But that's my opinion on it.
Councilmember Benquino, did you have any thoughts at this time?
Just that I think we probably open a can of worms. And this is going to happen again and again and again. This is going to be the basis for future, appeals. And we have to be very careful with that.
Yeah, but I think with what's before us today, we have to make a decision on 1, 2, or 3. So do you have a preferred option?
Yes, number 2.
Number 2, okay. So it sounds...
This is in the best interest of the city, in my opinion, to avoid, because we already spent over $20,000. It's going to be a lot more money spent on this. Okay.
So the question becomes, let me ask the attorney this.
Sure.
Do I open it up to the public before a motion is made?
It's, I haven't been at your meetings. I don't know if you have in your rules of procedure when you open to the public or not, but I would think you should allow the public to speak before you are ready to put a motion on the table.
That's normally this is
Yes.
not the standard circumstance, so I just want to make sure we're doing everything appropriately. Yes.
We also have the representative from the Florida Municipal Insurance Trust on the line as well, and I'm not sure if they want to have any input or not.
Yeah. And if I may, just as a procedural matter, when I wordily interrupted with questioning Mr. Bayer's presentation, I believe he did have a few minutes left, and I'd like to hear from everybody, including whatever time he may have had left, if we can figure out what that was, Dennis. But
Yeah. All right. So we'll listen to the Florida, Virginia. What they're the
Mr.
Any comments? What's the gentleman's name?
Sorry, my name is Jason Zimmerman. I'm an attorney at Gray Robinson. We represent the winning bidder. At this time, we're not a party to this appeal. We agree with Mr. Schumer, and I would have to consult with my client whether or not they would object to the third option. We obviously believe that the bid process was right and the appeal process, as Mr. Schumer has laid out, was not followed. But of course, we are not a proper party in this action right now.
Okay, thank you. Mr. Bayer, did you want to take your remaining time? It's like 4 minutes.
Yeah, I had 5 minutes 45 written down. I don't have a timer for that, so I'll hit it at 10 minutes and we'll go from there.
I don't intend to run out the clock. I think you've heard our position. But again, our main position is that the surety bond provides the appropriate security to the city. Your code does not provide us with procedural due process as far as, with all due respect to Mr. Cuff, who I have known for about 30 years, how do you determine whether our appeal is with merit or without merit? It's not a standard, a lot of contracts says prevailing party gets their attorney's fees if they win at trial. Well, there's also a thing in Florida procedure that if it's determined to be a frivolous case, there's criteria that apply that the courts can look at and say, yeah, this has merit or this doesn't have merit. You don't have any process in your code. And that's why we felt the surety bond protects us, protects the city, the money's there. We think that, again, under the case law that we cited previously, that the courts have already said that it's not a material factor. We think that the hearing officer got it right. Again, you got somebody that's a neutral third party, doesn't have a dog in this fight, and his position is that under the code, that the bond is not required for this step of the appeal for the county, or excuse me, for the city commission or city council to hear the appeal and determine the facts on the merits of what have been presented. Thank you very much.
Thank you. Okay, counsel, I'm going to, at this time, offer the option for any member of the public wish to make public comment on this particular agenda item. Please do so at this time. You have up to 3 minutes. Please state your name for the record. That is by calling in at 386-223-1690. Do we see anyone?
No one there.
Okay, thank you. We'll close public comment. I don't see anyone in our chambers as well. Okay, so I will take it back to this council and entertain a motion.
I'll make the motion, number 2, to reject the recommended order from the hearing officer.
I'm sorry, can you repeat that? I didn't hear.
Number 2, I'll
Yeah.
make the motion to
Okay.
reject the recommended order from the hearing officer.
Okay. Do I have a second?
Question on the motion, and allow Priya sufficient time to adjust if they choose to do so?
Is there a second?
Yes, that's what number 2 says.
Yep, number two, and it's full verbiage, understood.
Well, yeah.
Is there a second?
I second that.
Okay, then we can, discussion. Councilmember Cuff.
Well, discussion is, yeah, if the motion is to reject the hearing officer's proposed order and allow the appeal to go forward, provided that the appellant complies with the surety provisions of 2-29 as it's written, not as they construe them or think Florida case law construes them, since we don't know what the circumstances of that case were, then yes, I'm in favor of that motion. But I do want to see this move forward. I mean, if the ultimate determination with the hearing officer and then with this council is something they can't live with, that's what courts are for.
Yeah.
But I'd rather, if it has to go that far, I'd rather it doesn't have to go that far. And it seems to me that the current motion gives them ample opportunity to cure a procedural defect in my mind, and that the law will protect them if they feel like somebody's going to confiscate $54,000 from them without adequate grounds for doing so. So I would support the motion.
Madam Mayor, if I could ask a question on that. If they refuse to comply, let's say the motion that's on the table proceeds forward, and they refuse to comply with your bid protest procedure with regard to the bond, what is the remedy for that? Does that stop the process then?
Well, it would. I mean, that's the motion on the floor is they must comply.
They must comply, or the hearing officer does not then proceed to the merits, stops it.
That's my understanding. Yes. I mean, it wouldn't move forward if they're not complying. That's, yeah. Okay.
I have a note regarding potential deadlines you may want to consider. This is Jacob Schumer for the staff. Right now, we have scheduled a hearing to confront the merits for November 12th, so that this same city council can decide the issue, so that we don't have an issue of facts being determined and explored by one city council, and then a whole new city council actually having to decide the final say. And so if the council is going to set a deadline for Priya to come into compliance with the code, I would ask or recommend that they do so, so that they have to come into compliance before the 12th, so that we don't have to have a whole blown hearing when nothing is actually going to happen.
So there needs to be an amendment to the motion if the motion maker so wishes. Meaning you just need to add the date, the deadline, Eddie.
And what's the deadline again?
November 12th.
That's the date of that the hearing officer set for the next hearing, depending on the results of this hearing.
Yeah.
Amendment, would the second agree to that amendment?
Yes, absolutely.
Okay.
I agree.
Okay. That would be sufficient. The amendment, Virginia, you have the understanding of what's required?
Yes, I have. The motion is number 2, which is reject the recommended order from the hearing officer to deny the motion to dismiss, instead grant the motion, and allow the alternative that Priya will have until November 12th to provide the appropriate bond and allow the appeal to continue if the bond is provided, and that date is November 12th.
Yes.
Madam Mayor, if I could interrupt again, I think that you would want it sooner than that, because if they do not, that will save the city a lot of money, because you won't have attorneys preparing for a hearing that isn't going to happen, because they don't find out till the last minute. So today, I believe, is the 2nd. I can't imagine why, they can't agree to do this by the end of this week or even within 3 days of the hearing today. So, the city is not basically having to pay all of us to prepare for that second hearing.
Just for the record, Dennis Bear for PREA, we'll let you know by Wednesday of this week.
That's great. That's great.
We agree.
So, give the date then to.
Close the business this Wednesday, which is the 4th.
Okay. Close the business.
Absolutely.
Can you make that amendment? Okay.
Yes,
Yep,
I'll
nice.
make that
Second
amendment.
Yep.
Virginia, that's clear?
Yes.
Okay, thank you so much. Okay, I'm going to call to question. All those in favor, please say aye. Aye.
Aye.
Can you do a roll call, Virginia? Thank you.
Vice Mayor Clufus,
Aye.
Councilmember Branquinho,
Yes.
Councilmember Cuff,
Yes.
Councilmember Netz,
No.
Mayor Holland.
Yes.
Motion passes 4-1.
Okay, thank you. That's our business for today.
Yep. Motion to adjourn.